The key to a successful bankruptcy hearing is being well prepared. Your bankruptcy petition should have been prepared by an experienced bankruptcy attorney. The petition and supporting documents are the foundation of your case. If done correctly, it will be much more likely that you will have a successful outcome. Your bankruptcy attorney should send the petition and supporting documents to the bankruptcy trustee at least 2 weeks prior to your hearing. The bankruptcy trustee is an attorney who's paid by the court to ask you questions. You will be meeting with the trustee on the day of the hearing. If needed, the trustee will provide a translator. On the day of the hearing, dress business casual. When you enter the building where the bankruptcy hearing takes place, you will pass through airport-like security. Allow yourself plenty of time and try to arrive at least a half hour early. When you get to the room where your hearing is to take place, take a seat as close as you can to the front of the room so you can observe people going before you. By observing others, you have a much better idea of what to expect. While you're waiting for your case to be called, have your ID and Social Security card ready in your hand. When your case is called, you and your attorney will take seats at the table in front of the trustee. As soon as you take your seat, hand your ID and Social Security card to the trustee. The trustee will compare the information on them to see if they match the petition. There are two main purposes to the bankruptcy hearing. One is for the trustee to determine whether you have any non-exempt assets that can be taken to pay your creditors. The second is for the trustee to ask questions to determine whether your bankruptcy petition is fraudulent. It is essential that you always tell the truth. If it is found that you have given false testimony, you may not only be denied a discharge of bankruptcy, but you may also be prosecuted for a crime. Accordingly, once the trustee checks your ID and Social Security card, the trustee will swear you in. You'll be asked to raise your right hand. The trustee will ask you to swear or affirm that everything you say will be the truth. Once you say yes, you may lower your hand. The trustee will ask you for your name and address. You'll be asked whether the signature on the petition is yours and whether the petition contains all of your assets and debts. It is important to remember when you're being asked whether the petition contains all of your assets, this includes assets such as a home in another country. You will be asked whether there is anything you wish to change at this time. If you have accidentally or intentionally omitted something from your petition, this is your opportunity to tell the trustee. Additionally, if circumstances change since your petition was prepared, you should inform the trustee. The trustee will ask if you ever own real estate. If you have owned property within the last 6 years, your attorney should have already provided the trustee with information about the property. The trustee will ask if you are suing anyone or have the right to sue anyone, for example, in regard to an auto accident or slip and fall claim. Again, if the answer is yes, information about this should have already been provided to the trustee. You'll be asked if you expect to inherit anything in the next 6 months. You'll be asked if you have a bank account, and if so, what was the most money you had at any one time in the last 2 years? If you don't have a bank account, you'll be asked how you pay your bills. The trustee will ask whether you have transferred anything of value to anyone in the last 6 years. The trustee may ask what caused you to get into debt. If you have large debts, the trustee may ask the reason for them. You may be asked when you last used your credit cards. Have you paid any one creditor more than $600 within the 3 months prior to filing your petition? You may be asked if you took cash advances, and if so, what did you do with the money? The trustee will review all of the sections of your petition and will ask you questions based upon it. Although you don't need to memorize your petition, you should be familiar with its contents. If the trustee is satisfied, the trustee will say that the meeting is closed, which means you are done. If the trustee has further questions, a second hearing will be scheduled to allow you more time to provide the trustee with the required information. Although filing bankruptcy can provide you with a great deal of financial and emotional relief, if it is done incorrectly, you risk much. It is essential that you use the services of an experienced bankruptcy attorney. If you hire such an attorney and fully cooperate, you may be spared many problems and much stress, and will be provided with a fresh financial start. For more information on this subject, call us for a free consultation.